With a word of prayer, I'm honored to call upon our legal draftsperson to lead us in prayer. Thank you.
Let us pray. Dear Lord, we come before you this morning. We give you praise, Lord. We're grateful for all the blessings you pour upon each and every one of us, your leaders and the people of this country. We're thankful, Lord, for everything that you do for our families and our loved ones, communities, our government, our people, Lord. We're grateful for opportunities like this morning that we come together to go through crucial laws for your country. Lord, we ask that you please be with us today. Help us, give us good, constructive thoughts so we may build through laws the benefits of our country. We ask all of these in Jesus' name. Amen.
Amen. Thank you. Thank you very much, legal draftsperson, for the opening prayer. Let me, on behalf of the Bills and Legislation Committee, thank you, PS, and your esteemed team with the Attorney General's chambers, of course, for appearing again before us. We've have a short break during the weekend, and I believe from what I can see in your presence this morning that we are ready to complete, hopefully, the remaining clause of our bill this morning. We will start with Part 10, Employment Grievances, Clause 92 this morning. Let me also introduce my committee members present. Now on my left, I have Honorable David Keenan. On my right, Honorable Matiwale, Opposition Leader, Tematuvatu constituency, Honorable Frida Tuki, and the powerful leader of the independent group in Parliament, Honorable Manas Mailana. So we are pleased that you appear before us this morning. As I alluded to, we will jump straight to clause 92. We are on the clauses discussing, so we'll start from there. I will now allow again, I'm obliged to remind you, you still have our privileges, parliamentary privileges with you, so capitalize on that when you make presentation to us, PS and your team. Thank you. We have clause 92. Any comments, question on clause 92?
Chairman, just in terms of the definition of action, law 92, and good lobby, it includes omission. So a decision is an action you may refer to, that's a decision, or it includes it.
PS.
No, more a legal.
Legal, okay, let's give the opportunity to the legal drafts lady.
Honourable Chairperson, that is correct.
Thank you, Leader. Any further comments, question on that clause 92? If not, then let's proceed on to clause 93. '94.
Just in terms of this right to legal proceedings, so if complaint was made, and then at what point can a person have recourse to legal proceedings?
I will attempt to answer the question. Honourable Chairperson, thank you for the question. This particular clause, it's like an investigation, or this is the start of an action under this part, employee grievances. An action that is progressed under the provisions of Part 10 does not stop anyone from taking it from the same scenario or actions under another law, taking legal proceedings in respect. So if it can be also charged under penal code, for example, yeah, the same, this 94, clause 94 says that it does not stop. Yeah, it can be ongoing.
Right. Okay.
Thank you, legal drafts person. We move on to clause 95. Thank you. There's silence. It allows us to keep moving. Clause 96, we are now on Division 2, complaints.
What's been the practice so far, PS, in terms of complaints made? Usually how long after a decision's been made?
Thank you, Chair, and thank you, Sir, for that question. In terms of the current practice now, actually, I'm not got a proper way of proper channel in terms of doing what they do. Is that outright come to PS. If they were or not happy about any decision, they write to the PS. But not the bills and provide them the way forward in terms of how to deal with complaints when they come to issues of discipline.
But the number of complaints you've received, any range in terms of number of days after that action was actually taken?
Yes, some range, yeah. Sometime after, maybe latest, maybe around 2 weeks. Sometimes a month later, if you receive more complaints.
Okay, yeah. But no more than a month?
No.
Okay, so people usually complain within a month?
Yeah. So I'm range if issues affect him, because especially logata, but suppose I'm affecting water, they raise him as soon as possible. That's depend what time, not let us arrive logata, yeah. If those issues arrive logata, then they could raise a complaint. But and I'm saying between 2 a month, but from experience.
So you mean letter arrive logata also, or matters relate to their appointments?
Any issue, whether personal issues logata or things like for under this for close lawyer, yeah, must employee grievances or any issue. Yeah. So any issue at all, matters of discipline, that one I'm going to process blame where if a decision is made by the PS public service in terms of their discipline, by process law, what have to apply the commission that one. But in the issue apart from discipline, matters relating personally relating to them, and I say range not necessarily. It's taken about 2 weeks, 1 month, or so, that range.
Mm-hmm. And so here it's dealing with employee grievances, a report of malpractice or maladministration or something. Basta ka andalo ito here.
Yes, correct, sir.
And so far, okay ito within a month you receive them now.
Yeah, I'm depend on certain decision, certain action I'm done. No, suppose there's an issue where the employer have not happy about certain decisions we made in that arena, then a complaint could be made. But I'm not saying that every time you receive complaint, not necessary. Every time there's a complaint come, maybe 1 month in a month and once no more can't happen. It's not necessary where every time you look in complaint. I'm
So
calm.
you don't have the risk that, because here you say within 28 days after the action is taken, there is no risk that that is too short, and therefore this would bar any complaints that are valid, that ought to be looked at, but can come within 2 months or something. I know there's discretion on the part of the Commission and responsible officer to extend, but that's qualified by having exceptional circumstances for doing so. I'm just thinking in terms of some matters that perhaps employees may not have the confidence to come up, and they need time to process it within themselves and really build up confidence to then make a report.
See, I think the days alone, I'm okay naman.
Oh yeah?
Yeah, I think it's I'm okay naman.
Sexual harassment would be covered by this, employee grievances? They could report sexual harassment under the...
Yeah. Yes. Can you show some report to come, which is certain cases happen low service time and based on the reporting where certain people report some cases and then we deal with those situations.
Because the evidence, anecdotal, but the evidence globally, especially for women, when they're harassed, they take a long time, about a fright or a shame. They take a long time before they garner the confidence to do something about it. But this 28 days would seem to me too short for that kind of serious grievance to be reported. And secondly, the discretion given to the Commission or the responsible officer for exceptional circumstances cannot be open-ended, or cannot be too long more. So if I would say, okay, another 28 days, I am double now. But beyond 28 days, maybe I'm start to get marginal. I'm just thinking those kinds of sexual offenses are, very serious, but usually women would need a lot of time to process it before it's we have this evidence. You may read him this fella report you take him come last time family violence or something. And when was that report you brought to Parliament? In any case,
White paper.
Yeah.
Yeah.
You cited some cases.
Yeah, I think there's another paper between Ministry of Women and
Justice.
no, public service about women. They call inclusive. Yeah? I think you remember. We have passed it in the cabinet that we have to recognize the women and also harassing women during their employment with the government. The other thing, Chair also, we like ask about there are a few cases maybe I come across during my time in the ministry. There are some employees like they do more serious things where what should be automatically, but keep on paying them half salary, almost 2-3 years, especially for those corrupt officers. What now? They keep on keeping those employee and come into what now? Yeah, solution for end them up or you may keep him also. I think there are a few employees I know they still today you may still pay him half pay or still use him or resident law government. I think that's one good for you must action take it not take him action quick time rather than you may keep on leaving things slow there. I think this activities should be including need for take serious action. Women should be respected inside law during their employment. Even also promote recognize them with the women. Not through sexual, but should recognize them with through law capability. Or that one, Chair. Thank you.
Thank you, Chair, for those comments as well. Thank you, member, for those comments as well in terms of the disciplinary process law, public service. Chair, in terms of the 28 days notice here, 20 days after action is taken here, actually, key meetings at the part 4, at 964, and provide for we must extend in time.
Yeah, but extending time, yeah, but how long an extension then becomes unreasonable? LD, can you help us? I'm just specifically worried about sexual harassment of the serious kind.
Thank you, Honourable.
Maybe we put an exception here or something. But anyway, yeah.
Perhaps Honourable Chairperson and Honourable Committee, the guidance under Clause 102 can assist with this, categorizing. 102 provides, Clause 102 provides for guidance about complaints and internal reviews. So complaints can be categorized, and for such complaints of sexual nature, this allows the permanent secretary to assist, to have that guidance. Particular, the process for that perhaps it would be different from the process from other kinds of complaints. So 102 may assist, and also 95, Clause 95, where if there's such guidance available for perhaps a different process for offenses of sexual nature under 102, and have that clear process of acknowledging this, it is not just a number of days, it can be years for particular matters, especially of a sexual nature within the office. That can be, permanent secretary can develop that under 102, and in 95 make use of 95 to take all reasonable steps to ensure that all employees know that this is available to them for these internal reviews.
Do we, in terms of the law, LD, so sexual harassment is under the penal code, right?
Yes.
All forms of sexual harassment.
Correct.
And therefore, we were talking about this. It's one of the issues you've taken on advisement, and this bill prevailing over other laws to the extent that they are inconsistent. So the punishment for sexual crimes under the penal code are much higher, and also the reporting of crimes is not time bound. Is there after so many years you cannot prosecute a crime, or it's open-ended?
Some are open-ended.
Some?
Yeah, some are.
Not all?
Yeah, not all. We will need to check if.
Check if
sexual offences, no.
Sexual crimes offences are
continuous.
Open-ended. Yeah, in which case, then it would have a bearing on how this section, particularly for sexual offences,
yes,
interfaces with it, and we're going back to Clause 5 on that.
Yes,
how it relates. Okay, Makem, that one important one, that one.
Right. And Honourable Chairperson and Honourable Committee, it goes back to the first clause that doesn't stop the ongoing, the proceedings, criminal investigation ongoing. So at times, in reality, if this is taken under counsels for parties would say that this, in order to prevent the part about double jeopardy, in recognition that don't want to bar under a lesser penalty, councils will need to bring that up. That there's also so perhaps there may be decisions made at the time that take those legal proceedings under this act or the penal code at the time it happens.
Yes. Ideally, if a report is made for serious offense like sexual offenses, then the matter gets immediately, any criminal matter, theft, forgery, fraud, gets immediately referred to the police.
Police.
Then what action should the PS take? That's, I think, also a very pertinent question, because one is innocent until proven guilty. Does the person keep working? Does he go on half pay after an internal investigation? So that's just an administrative process without dealing with what charges are laid and so forth. So double jeopardy is avoided. But at the same time, protect against, false accusations. So if someone was falsely accused of a sexual offense, and the matter is referred to the police, criminal process kick in, we do need to recognize if, a situation where accusation is false or substantially false by an unfellow person, the accused person. So the administrative side of the process needs to preserve that possibility also. So it needs to strike a balance. But sexual offenses are a real problem. They're a real problem in the public service. They're a real problem everywhere. They're a real problem all over the world. And so we do need to take it very, very seriously. No good you may deal with it administratively no more than with small fine no more. By money go more go. Hold him some woman more. No mas good here. Okay.
So thank you. We'll take note of those comments you made, and we'll formally write to the LD to look at those issues and instruction go on. Then for look, those issues to us are very important too. Like these are serious issues where we follow public service we will deal with them. Issues of sexual harassment, me no sa give tolerance lem termination statement me give local niya. So me terminate him to trivial man law issue finish.
Then you refer him to police?
No party am stop lo milo no more. The only issue no more is that because once evidence come, me terminate him no person in based evidence. So usually what me find him so far, those people even for appeal commission, what no sabi do me. Because suppose evidence of stop law is quite difficult for you to tell them commission mo for me sa tayo na me do something no look. So me just me looking evidence him come front lo me looking then this evidence. Me no gar some second thought lem first thought lo mind lo me termination na because some summary dismissal which is to us getting these people out from the service na good for the service. If you transfer from point A to point B, bam go was small point B. Because you did nothing with it. So to us, in police intention is that at least that person must take a maximum penalty or what him to him in terms of those nature of the case like sexual harassment. This immoral tolerate him is a big issue. So in the service, we want to try to weed out those people who do not and something the same. So suppose evidence come along me with him, but in terms of what you mentioned, say like if me follow side law here, then will give me one side go police and different case more kind of same. So that's I understand what you're trying to say in terms of due to severity of the case, that person could also be referred to other acts for punishment. But to us, we'll stop playing no more.
So should that be in here? Should it be in here that the PS is duty bound matters that in his opinion, on the basis of evidence gathered law investigation here, that should be referred to the police and must refer him. So that terminate him no more, then him finish law there, soft punishment no more. Criminal matter, I must go to police now. Should we include it?
Thank you, Sir, for those comments. Yeah, I think Baba for look some should be part of recommendation as well. That time we look low. I
think such actions should be punished for 5 years imprisonment in Family Protection Act. Yeah, and a fine of maybe 50,000 or 20, I forget already. So that one you should not take it, you should take it seriously so that inside law, environment in the workplace should be, we have respect, protect our women. I think I may support him chair. You may should include him inside in this one bill, so that we.
Thank you, colleague Tufatu. I think that reminds us again. We've agreed that you need to go back to for lulukulo at the penalties, make them consistency. But what the leader has raised, quite important because severity law matter. By no stop you. Go on further for further actions under other laws in Mikarim, like the police for taking further action. Thank you. You have further comments, Alina?
No, 97.
We are on 97.
97 2 Chairman. Why not? Well, agol belum ini belum why not ya man? Agol belum maniati ya. Saya mengharap kami saya mania kolem nem belum ini.
Thank you, PS.
Okay, thank you, Chair. Thank you, Leader, for that question. I think Bami answer go, but then maybe the legal draft special and clarify more in terms of that one. But to us, I think this one is more based on individual type of complaining. Patient making complaint from an individual. So I think just tell him here. If it's going to be a collective, maybe we have come through other part by me go but this is a person individual making a complaint. I think it's all part A, it's all part 10, division 1, 2, and try for mention. But let LD could assist us in terms of the wordings here. Thank you.
Good drops, lady.
It's really a policy.
Policy. Okay.
But PS, I don't see any good policy logic or rationale for this prohibition. Of course, probably by and large, individuals will make complaints, but you shouldn't bar, 2 or 3, maybe even 4 people who witness something, and then everyone make them complain, and they strengthen them go more complain. If when I first had a glance at this, I thought perhaps the prohibition here is just so that none of these matters are used in, say, industrial disputes. But, well, that's fair. Those are different matters, and industrial disputes should not be about personnel issues. It should be about welfare and other trade issues also. But I think we should allow situations where more than one person will make the same complaint.
Chair, I think we took note of the comments you made in terms of this one. We look at it, and like as you said, there could be more 1-2 people. I think by making issue really more, getting a balanced view from 3 or 2 people. Maybe we understand what you try to say. So we look at the matter and take note of it. Take note of take heart na make him. You tell him for take note dry and for take note heart na this time.
Very good, PS.
Thank you, PS. Take point lahem lo heart, and I think the right when someone need to exercise him lo and also justice. So good name take him lo heart.
And in all of these things, in complaints process, they could invoke the Whistleblowers Protection Act. Yeah?
Yes.
Okay. So a person making a complaint would be told you also have rights under the...
Yes. And Honourable Chairperson, like we came across that clause that the ministry authorized will explain everything that you're entitled to under the whistleblowers and supports the employee when they wish to take action as a person making a complaint under the whistleblowers. So I just, if it is a policy, the 97.2, absolutely, it's like it's particular just to one person, to allow that one person to, but perhaps it does not stop another person from. It's like it's made available. 97.2 makes it available that one person can do it. It doesn't mean that another person cannot make a complaint across the. But yeah, I'll leave that to instructions from.
On the same issue.
Yes, correct.
So that's fine, but where more than one employee want to make the one complaint, we should allow that also. The effect of it will be the same as 10 people making 10 separate complaints about that one particular action. Well, why can't they be allowed to sign on that one action? If you're allowing that, then it makes more sense to allow them to do it together. In terms of process normal PS, I'm wondering whether there is a standard complaints form. We're going to fill up and OSEM, and they can attach evidence or statements or OSEM normal or the right normal.
So normal. Currently, there is no standard form on this email.
I think you should.
The right normal. Then I think this one here, I think by in the bill now we'll have the pathway for that. A form will be made for person who would like for making complaints. What you should not form. Currently, no informing. What we do now is we receive complaints based on letter writing problem.
Okay.
Based on case by cases. Thank you.
So maybe in that form, I think it's good to have a form. And if they want to provide more evidence or more information, of course they can attach it. But a form, what would be helpful, the form is to make sure that all the provisions protecting their rights are cross-referenced, so they can go to the law and say, oh, yeah, I'm making a complaint under this provision. But especially the option that they could opt for protection, whistleblowers protection, that must be on the form. So they are deliberately and knowingly making a choice. They're making that fellow complaint, and therefore how the ministry will deal with it.
Thank you, sir. We take note of that. The form says definitely yes, Baba for development, and those issues you raise him could be part of the form as well. Or we protect him now, what man in terms of time with him reporting, and then no good report come, then man the report him against him, ask him, oh no report him come. Like you said, him Solomon Island no more, so sometimes things have start profile. You present you tell them go, but maybe somebody him whole registry him style or something yeah. Oh, Jack na report him something so him become personal issue more man kind of thing. So we take note of those citizens.
Thank you, Thomas. PS. If no any further comments, question on clause 97, then can we move to clause 98? Thank you. Clause 99.
Yeah, clause 99 here. 1A will need some guidance as to what constitutes frivolous and vexatious. I wouldn't expect that a responsible officer or even the Public Service Commission would be necessarily trained in making such a determination, so some guidance would be useful. And then the 1B, this one me worrying first time, Well, member Temo to what to a little bit talk the first time, especially with regards to sexual offences. Yeah? Complainant unreasonably delayed making the complaint or initiating conduct of internal review. So on the one hand, they've started, you know, the person is innocent until proven guilty, but this one you may deal with him administrative arena no more. Yeah? So on other matters, perhaps I'm all right, but where there is corrupt practice, that one I'm under the penal code, and so should not be time bound, but LD by researching for Talimimi more. And then not sexual or other penal code offenses, those should not be time bound.
So thank you for those comments as well. Yes, for the first one, but actually what will happen is that the team will be doing awareness in terms of this one. Once those things are available, we could do a socialization in terms of these forms across the service now. Then we, by explaining good law, come on, this social racism complaint, these are the forms and section 991A, yeah, by me explaining good law now, what not, that if the nature of the form can fly, what I fall in that. Okay, in terms of the issue you raised in terms of the delay in the matter, whereby it's serious in nature, we will deal with administratively now, according to law here. If, for example, if a case has been reported to me, and then as a PS, we have to instinctively act upon that case, either if the evidence is so overwhelming, definitely by me suspending person the first time, then allow investigation from going, put him out from that office for my teams are moving and doing investigation. So that's the current practice that happened this time. Once an issue is reported to me, I check on evidence, me looking at Hempstead and call my team or PSU for look lemma, and then we talk and for look at the evidence big to us. Within that week, person him suspended there, and then we follow investigation. The only issue, no more time on investigation, case delay this time because of evidence no more. Once evidence, because we're looking at the serious of nature and time is start for interviewing people. Sometimes time we go inside with interview, several months, what withholding a lot of information to us. Yeah? So that takes time. So you have to force him from talk to. So currently those are the issues involved facing in terms of time, things and delay. It's not us delaying, but it's the information we get from people who is causing those delay to us in terms of how relay information. And then suppose you investigation go no, then so this one evidence, then you stop over there. By within that office, by looking what people say, last time, why not now? But we cannot just suspend the president or terminate the president just because to talk and come that man but there's lack of evidence. How can we do it? So, and then backfire too, just me terminating him go around taking me to court. By government and file more. So we have cases that happened in the past the same too, where people been terminated and then they taken government to court and we have to pay for some kind of thing. But in terms of sexual harassment, to him terminated him and win him because as long as evidence are there, I'm quite a challenge in terms of challenge and evidence him coming. Because some of the issues here him go as far as him go online kind of same Facebook and kind of time was him kind of same issue where that person him text him go na several rubbish picture and kind of type of him and ask go. So does evidence in him come him tough. I mean to the person him doing difficult silence him too. So once him take him quite cellular then, but as you said today, him should not stop there. Him should always go come managol person. No go stay mo, go narawaka mo, then do him something mo. But I can see that those people who've been terminated, certain people, me look but to work certain places more this time. So we take note of that very important thing you talk about say because
certain places law public service more.
No. I think a private man or even I must take him out. But I saw them walking somewhere within the Honiara small place no more. So Imi drive around, imi looking kumane, wakalo part A, part B, or same, so yeah. So I think what you said earlier, him should not stop there, him should always make him put him on him, got him consequences of what him doing in terms of one. Thank you, sir.
So that raises 99(2)(c). Well, I suppose B as well. I'm good. Responsible officer and the commission counsel the complainant. So this is about counseling of the complainant. And then law C, warn the complainant that repeatedly. So how often now? It has to be repeated for it to become repeatedly.
Come again, say in terms of this one?
Law C, say warn the complainant that repeatedly making such complaints, frivolous, vexatious name, or delays is a major misconduct. So first, making frivolous, vexatious complaints, and true na. You make them once, and frivolous, vexatious. You make them twice, and twice frivolous, vexatious, and she must not be encouraged. But delays here, second part here, delays, major misconduct.
Like could be, the intention was him should be once no more. Once that happened, you go to second round, mama, hey, integratively, at stake in terms of as you write him complaint now, because the first one he was looking, but the policy intention was him should be once no more. Once that one I'm doing, then.
Is there a feedback loop? So is a complainant informed of what decisions were taken by the commission or the responsible officer? Lo complaint blame at the end. No good no start na so I'm go make him complaint ba no good file out toro no mo so me go make him second round mo.
No, so in terms of responsible complaint, yes, once I'm come, then we first respond local personally in terms of letters, reply to them what course of action has been made in terms of the issue they raise.
So once a final determination is done,
yes,
inform complainant.
Yes. Yeah.
Okay. Does that need to go in here or no need? I don't see it. Or is it coming later? Or?
Perhaps by guidance, Honourable Chairperson?
Yes, Trustperson.
Perhaps by the guidance that will be prepared by the ministry under clause 102, the process for all complaints, internal reviews, making complaints, the content of those complaints, how to withdraw a complaint, and how internal reviews are attended to. Guidance will be provided under 102.
Yeah, but none of those things listed refer to what happens at the end of that process and the right of the complainant to be informed about the outcome of that process. That's not included here. It should be included if you are saying, you know, delay is a major misconduct. That's a big bar to put up, you know. It's a very high jump. But make a man for fright for, if I'm go beyond 28 days, I'm fright for report him now because I'm running risk of major misconduct. I mean, delay surely is not a major misconduct. Really? Do you want delay to be a major misconduct? I mean, delay should be discouraged, but it's not intolerable.
Thank you, sir. I think one, but delay issue maybe it's not really sometimes you scattered too here in terms of the promises in problem. So sometimes letters and take time to for a table law pressure. So to us maybe delay should not be a major major misconduct. Like could be in the sense that Honiara, yes, but if you go to the provinces, it's quite difficult to get things as soon as possible. Honiara, you go as far as north, east, Temutu, Western, Shortlands, because these are the places where public safety staff will have. So that should not be a major misconduct, I think, because that's, unless M deliberately do it. But that's one law provinces and send them come. Experience that, someone writing or correspond come, sometimes after 2 weeks now, if I'm in the Kamlohonera, or so unless they have access to emails and could email them come direct. But currently, all the provinces here, when they write correspondence to us, and by letter no more. Once I write, sometimes later, last month, I'm coming after 2-3 weeks before you. So to us, that could not constitute a major misconduct. Unless the thing is in Honiara, when next door, nobody will report him come, that's good. But that one should not be a major misconduct. Thanks.
Okay, so some delays here, no more remove them.
Yeah. We'll take note of that issue, right? As part of the instruction for giving law AG chambers for doing that one.
Okay.
Thank you, PS. Time complain him race come with him you what mode name acceptable, yeah? Like you talking about letter, email, WhatsApp, text or something. Yeah? By guideline him helping me for complainant understand him which one him acceptable.
Thank you, sir. I think the guidance in that, I think we're helping me learn what the mode of communication now he means have accepted in terms of time come. But mostly now him obviously him letter no more. Letter. Sometimes the provinces sort of scan him those documents and send it to us through email. We could accept that. So I think with the evolving technology, we could use other tools available as well. So the guidance under 102 will help us in terms of how enough him accepting which partner, and then the genuineness of the issue send them come to in terms of kind of saying WhatsApp. I think Baba me not really sure because no good. Me not say what kind of number na money send them come lem or who me talk with them. Me for looking to what of him. It's good to see the name of the person who actually and then what na position rem law that area. Thank you, sir.
Honourable.
Yes, legal trust lady.
Thank you for the discussions. Just, to put on the floor also for the discussions with the ministry. If we remove delay, is that useful or is that beneficial for the, if we remove it, then there may be, I mean, if we have it there and have define what is delay according to certain circumstances, if we remove it, there will be nothing for the ministry to rely on for long upstanding matters, but it comes back. So just for some thoughts in moving forward, because I'm just conscious of having it in there and not having it in the law. So put it on the side of the ministry. Thank you.
Well, already you have, we were talking about before, already you have 28 days with discretion in the commission and the responsible officer to say, okay, MSTAP law, Tikopia, there's only one ship that goes there a couple of months. You know, a nurse law, clinic or something. So surely 28 days is unreasonable in those circumstances. So special circumstances, so commission me or the responsible officer may extend them. Oh yeah, ship go every 4-6 months or 7 months. So 6 months, even 1 year, still reasonable. So circumstances will help to determine what's reasonable or not. That one makes sense no more. But delay becoming a major misconduct, that's another matter. So, you know, delay where really just an abuse of process, well, summary dismissal, and then write back and tell them that, hey, this one you report him finish, and action me will take him also, me will inform him you finish, and you make a more second complaint lo him more, you all right, or me will send him lo kiluvi also. Then him say, oh yeah, but would that be major misconduct? I'm not sure that they qualify for major misconduct. It's just that bit, especially Lord Dilly, repeatedly making frivolous, vexatious complaints, perhaps is bordering on malicious complaints. So perhaps that's the other thing that should be included here. You talk about frivolous and vexatious, but there's nothing here about malicious. So mane jolesim no manaro mane so make him go complain like ovum no intention blame me wrong and no any evidence for back him and waste them time law PS and PSU for look something and it's malicious intention, clearly malicious, and that should also be malicious, should also be criminal.
Yes.
Yes.
Is it?
Yes.
It is. So perhaps that's another something we will add them name, and then the complainant needs to know, needs to be informed by the responsible officer of the commission. But this was form here. That's why form here by importing a complaint form. Tell him straight now. If you make him complaint with malice, then that will be a matter, a criminal matter on you, backfire you if any seen to be with malice by you more, you must go to investigate you, something or same. Then that would be major misconduct. With malice complaints must be major misconduct. So then see but you must expand them on. But delays, no, delays cannot be major misconduct.
Thank you, sir. Okay, in terms of this one, I think the only by me have to define him no what now constitute major inside the bill, and this one, but like one should be a misconduct no, but major now you need to define him. Like a delay could be a misconduct, but it should not be a major misconduct. So I think the definition of major misconduct, you need for him put him on what now constitute a major misconduct. Then could understand it more in at which context now that one come in if a major misconduct is done. So I think we'll work with the Attorney General's Chambers, the legal draft person, for him to try to define him. It's one law bill. That's what we.
Yeah. So malicious complaints.
And also we could include this one too. That is,
Include him.
Yeah. So this will be part of our instructions to the legal drafter to include him now. That one you just mentioned yesterday. Thank you.
Thank you, PS.
So that takes me to clause 107. So 100 there. So somebody makes a complaint and then, or like for withdrawal, yeah? I'm good. Me just worry no more. Sometimes we do conflate and sometimes confuse in the process. Other times, I'm just abuse normal process. But you may take him custom come, for come fix him something inside law governance system and processes. So money me do him something where me very serious, major misconduct, or perhaps even criminal conduct as a public officer. Then him go complainant here, him go put him down tuval red money, or him walk on val chupu, and then sorry now cry and awesome. So, but you mean lo custom? Money go withdraw complaint here na. So abuse him custom for stunt him now a formal process inside law governance processes that should be prohibited. You saw do him chupu, you saw do him go give himself money or something or same. That one for personal relationship, it's got nothing to do with the at all. Law take him course below him, but between him 12, me sorry now. In other words, you admit him you're wrong in the first place. If him also, it's not an abuse of custom, but a true good use of custom. Is threaten relationship him, but there must be consequence for actions that are misconduct, major misconduct or criminal. So I don't know how you do that here, but I think we run the risk. We've already had KNM happen finish. But minus our public service, anything was him, someone him complained, then him withdrawn because of it go make him chupulo house or
Custom.
No, say that one me no experience me na suppose complain him come then person withdraw not any time me looking at one. Once him come if all running cost problem na kasi me end. Midway me man comes stop na case no I don't see anyone coming with that suggestion me like stop him na case. Maybe outside of us could happening in terms of the police or whatever, but to us, once complaint him come, I me kasi na because actually formally put him come na unless at my time in the public service I haven't seen any nature of such that where
but there has been withdrawals, request for withdrawal?
No.
There has been none?
None.
Okay.
Yeah. So once him complaint him come, if I register them and then we proceed with the complaint raise. So me at not in time me look him any complaint who has been missing come complaint and write him come to PS. So he withdraw the case and me stop him last time. No. Me follow running kasem and not cases here.
Because longo criminal law time or get something was happen and parties reconcile or custom or that's then taken into account by the magistrate in mitigation. Time look sentencing. It's at them not considered now in looking at the trial itself to see whether what's being complained of may be true. So is it a matter we should include for clarity? I mean, you've had no withdrawals, but you're providing here for withdrawal.
I think you also look ahead into what will happen in terms of implementation from this one. No, maybe in the future where somebody writing a complaint later time like withdraw complaint. But this could be addressed through maybe the orders for specify now if under how now I mean because you mean for look too so no case through one more than money come so withdraw case no good money go pay him more behind back door somewhere so those issues now you raise him say so actually we follow look here and talk about complaints straight no because we don't expect the things to happen like from my experience once complaint come na no one come halfway more stop the process here me garib issue sa Muslim. But as we tell him, we fall by deal with it at our level in sense that you can come this for complaint, you can withdraw more. Same you lie no more. Those issues when raise more. Time for asking patient when raise him na issue about stop him complaint, stop him na this for proceedings against the patient complaint against him. So a mechanism na kung stop in place of where we fall sa point A and B and C and meet him this one niya complaint must continue so as you complain him stop him then you deal with him to satisfy him to these conditions here and to some meeting in terms of this one so this could be more specified in terms of the orders you may try address him to this one to the public safety orders in terms of the complaints time president submitting complaint these are the conditions, and if the president like withdraw complaint, what conditions I'm satisfy him too? Because maybe in the future, maybe that issue him through one no more, then president comes stop him just because president him relate goal him more to all city to compare to get one church more. So those is making me satisfy him too. What not in what certain conditions now the case can withdraw if there's evidence already. For example, obviously looking at everything stuck on, then how do you stop him this one more? So if that case of semi, that means I think him. Got him any issue more, like maybe just because I'm good prelo money or kind of thing. So this could be addressed to the orders.
I'm just not sure it's something that you can use the orders for. I mean, the way clause 100 is worded, say a complainant may withdraw his or her complaint in writing. So the discretion is on the complainant. So once I'm withdrawn, you have no option but to recognize and register that withdrawal, and that's the end of your process, basically. You can't go to public service orders and say, you may withdraw, but tests for him or some grounds for withdrawal also. No, if you want to do that, you need to put it here. You can't put it law or regulations.
Thank you, sir. We take note of that. Because you raised a big issue, me just realize him in terms of that one. So I think we'll take note of that, and we could put it somewhere within this bill as well. So we'll be talking with the legal drafter for those issues that can be also addressed in this bill. Thank you. Because forward into the future, those are issues will happen. If investigation continue or present, later when it comes to withdraw something, then at what grounds now you withdraw time evidence and more than 100% left in here. What grounds? So those issues I think for discussion, and then we take note of it, and we will send that legal draft instruction to the AG chambers for Lulukulem.
And then what happens at the end? Just the withdrawals process no more. So we've got that. One MU Destalem by Lulukulem. But say in the normal course of business, a genuine withdrawal. A matter was withdrawn. It became apparent to the complainant that, I misunderstood the facts, and therefore, genuinely, I made a complaint that I should not have, and therefore I'm writing to formally withdraw it. What happens then? Because you register finish a complaint, so then presumably there's a register, so you register more withdrawal or time also, and then there's some comment or description of the basis of the withdrawal, so the register contains all of the information. Is that what happens? And then you write and say you formally accept the withdrawal. If you no accept them, do you write and say no, me no accept them withdrawal?
Say, just we mentioned today in terms of him fulfilling certain conditions. If that person apply for withdrawal, that's for complaint, and then he must meet him certain conditions if he put him inside there. Or that person, or genuinely, and so this one, just because me misunderstanding the fellow issue here, me report him come, but then provide for finish. Kind of same. So it could also be provided in this bill in terms of that one. I'm not what now. The certain conditions where you think that if a withdrawn cases, him based on this one. So conditions you must meet him. So it could be part of here as well. So, for example, if me make a complaint come and we looking that issue has been dealt with in Finnish law before, and this validation has been made. So those conditions, M2 should start law in terms of analysis OSEM by OSEM by a withdrawn case, kind of thing. OSEM for preventive man for come telling you more that things have happened in the past, but the issue a new issue altogether. Just because ignorance problems ignorance problem me report him case, but actually him sa finish for another condition and tell him miss withdrawn case because me no looking good now. What name talk about and these issues been already addressed in the past. So those conditions, I think by me you have to categorize him too. This conditions A, B, and C kind of same. Withdrawal can be made following these circumstances.
Okay.
Thank you, PS. Yes. I'm good for Lulukumolo clause 100. Yeah? Then you explain him, come him clear. Yeah? But it needs to be in there to take care of those genuineness in terms of withdrawal. We are okay with clause 100. Can we move on to clause 101?
Hello. 101. Yes. So these officers or the commission and the responsible officer, the confidentiality of complaints system, good. But if under law subclause 2 here, or the breach him, what now? What now, what happen? Is that an offense in itself, or is that covered elsewhere, LD? If 101.2 was breached?
Yes. Whistleblowers, yes. Just look up, Honourable Chairperson, we just look up the Whistleblowers Act. I think yesterday we came across the confidentiality of information cannot be, in the Whistleblowers Act, it's an offence to, a person commits an offence if the person, A, while exercising a power or performing a function for an appropriate authority, obtains the identity of a person who makes a public interest disclosure to an appropriate authority, and B, engages in a conduct that results in the disclosure of the identity of the person. This is a confidentiality on the identity of the informant.
Does that apply only if the complaint is made under the Whistleblowers Protection Act?
If it's made under this act.
But if they make the complaint under this bill, and this 102 subclause 2 was breached, is that an offense? What penalty would?
Penalty would go to part 12 for if confidentiality information is we have giving false or misleading information here only.
So which clause now?
Complaints confidential. So one clause, Honourable Chairperson and Honourable Committee, clause 101, its purpose is to state what is confidential information. That's the purpose of 101. What is confidential information for the purposes of this bill, this part? And then that's 101.1, A, B, C, and then 101.2 is protection of it. Protection and maintenance of this confidentiality.
So then when it is not with,
Okay, that's right. We'll look through the, this is the question, whether it's, because we'll look for the, if there's a specific offense for it, yeah, or whether it's, again, one of the matters, misconduct in performance management matters of an employee.
I mean, part 12, offenses and penalties, impersonating an employee, failure to provide information, giving false, misleading information, obstruction, misbehavior, theft of government property, undue influence, victimization, discrimination, non-disclosure of information. There's nothing about breach of confidentiality.
Yes, correct.
So I think you need to address it. It needs to be in this bill. There is an absence of sanction on the breach of 101.
Chair, thank you, sir. I think we take note of your recommendation. We look at the bill again, and then we'll see where another follow issue in terms of breach of confidentiality in terms of come inside. Thank you.
Thank you, PS. Yeah, as leader was just going through the other clauses in terms of penalty, it's not covered, it's not catered for there. So 101 Hemi need for address, and thank you. Now you take note of him. So now we can move to 102.
Below 103.
Okay, thank you. Let's move to clause 103.
103B, any other association. So, what are public employees' bodies, employee bodies? Some of them are not trade unions? Or
Correct.
associations, no?
Correct.
Some nurses, and
Yes.
not a trade union?
No, actually, what
They're not registered under the Trade Union Act.
the association and the recognition based on the scheme of service government ngara with
Oh, okay. Not registered under the Trade Union.
only kind of CPU la, and actually the
Trade Union. Why? What's the benefit of having two-file system or something? Why can't we just say, like for representative employees, you register under law, Trade Union Act, so we have only one mechanism for recognition.
Yes, sir, thank you for that issue as well. Yeah, currently, as Mr. stated, what unions blame me, I'm not association with him trade unions. So, like CPU is a trade union, SINA, SIMSA, ZILE, what association. So, those are two recognized. Parties where government recognizing what wakaman in terms of the association with them. So you have the trade unions and then we have the association. So currently, hemna imigaran. So for this bill, yeah, actually we try for formalize him na implement relations with him what trade unions and associations. So a member can be a member of an association or a member of a trade union. So trade unions, yeah, I'm covered under the legal draft that could help me in this as well, Trade Unions Act, and what association maybe auto registered under the Charitable Act in terms of the association. Yeah.
So I'm assuming, LD, that the Trade Union Act, because it's designed for trade unions, have some minimum rules in terms of their own governance, whereas an association registered under a charitable trusts, under the Charitable Trusts Act, is much more, I suppose, flexible is the word, malleable. And I'm just not sure from a policy standpoint, in matters dealing with employee issues, that an association should be permitted. Hem happen organically no more. Hem not happen as a deliberate by design policy decision. But really we should be saying there's only one gate for trade disputes, trade matters, welfare matters, and that's through the Trade Unions Act. You go register there, make them you meet him now, criteria tests under that act, and recognition, I'm granted that one. So then we move away from the scheme of service recognition here. The scheme of service one, no, it's not law. But once you put them law here, law na here. If you recognize them trade unions, then tell them nurses association, no problem. You have 6 months. Organize yourselves, go register law. Or even 1 year. You have a transition period for Allah Mogat for doing. But we should just have one door for recognition, and that's through the Trade Unions Act. LD, some wisdom from the East?
Honourable Chairperson, I believe this is best answered from a policy. The ministry's position when it comes to trade unions?
Thank you, sir. In terms of the scheme of service here, we mentioned him actually employed from the current act this time here, where been for public service, the minister in the sense, through consultation commission, controlize the scheme of service for the Wakam Hemla, that's how I'm coming, what these associations here, and provide for under the current act, or the trade unions here, I'm under the trade union act, where you recognize him what. So one through a trade union act, one through the public service act, where recognize him now, or the scheme of service, which is most of the like the SINA, GLA, whatever come under scheme of service where minister organization.
But under this bill, you're getting rid of those schemes of service. I mean, you're going to have those 6 cadres, you say by. Yeah. So you can't have one association per cadre. I would still need to be their own little trade association, trade union association.
Say in terms of this one, actually important provisions, but in terms of this one, I'm saying the Wakaman himself got right for joining any association or in trade unions. But the issue of the scheme of service, like him, I'm going to act bang. So suppose him stop here, the all act him go, then by me go to sexual card. But that doesn't stop us recognizing these people as per se in terms of the union or association or joining what. So by purpose this time, we can provide in the act now. He may recognize him also to stand for in terms of welfare block people who are members of the union or association. So the clause law in terms of the scheme of service, once that act him go and this one come in, naturally him dying. So we will not like the scheme of service here and not provide for under this current act. It only provides for members having association within any union or members of a union or trade union. But in terms of scheme of service, it doesn't provide within this current act. The old act name got him. So with this new act, he may go forward, he may recognize no members who are members of the union and the trade unions. But we may not go towards like scheme of service here. So the scheme of service will be addressed through the 6 Kada we talk about. The reason why immigrant scheme of service this time, because we provide the act where members have used scheme of service now for bargaining chip for addressing issue. Once this one come into being, the old act go, new act come, the scheme of service I'm out now. The scheme of service could be addressed through the 6 classifications he presenting during the course of the hearing Lobelia. So I think that's my understanding on the scheme of service plus the.
So it really is a legacy issue, this recognition of associations. Legacy below that old framework, my old regime, where I'm attached to schemes of service. So then, okay, you all because you all paramedics, you are a little bit different from our doctors, so you all by scheme of service different too, also. That will be now very different under the new classification. So if we're inheriting that, we would have to say, okay, well, those affected by the similar kinds of issues, you all are one association. So let me know Barrow makes sense. But in any case, I suppose my difficulty is I don't see the benefit between Tufale, maybe a comparison of what not policy benefit of recognizing a trade union for staff, employees, or an association, and which is better, or neutral no more, and so leave him also and flexible no more. I mean, if you're going to do a constitution and be registered and the rest of it under charitable trust, I would much prefer you go on the Trade Unions Act, because that act was designed for industrial relations. Charitable Trust Act was not designed for industrial relations.
No.
It was not. It was designed for other, charitable purposes. So, look also a deliberate by design decision here to recognize some associations. It's just organically happened, and can't blame him. Go no more. No. Maybe him quicker to register under charitable trust or something else. So, the convenience of it trumped all other considerations. So I suppose I'm asking you, go and have a look at both of those options, and then let's make a decision where from here on you make clean cut. My preference is everyone register the Trade Unions Act now. industrial relations are managed under that. Then time by you may amend them Trade Unions Act. You may look at the broader economy now. You may not look at there more, then you may come, oh, masafal under law Charitable Trust Act, but so you may go also more law Charitable Trust Act. It seems to me an abuse of the Charitable Trust Act to register what really in reality are trade unions under that file legislation. So in which case, then this one must change. Association must change. You all say no one gate no more. Trade Unions Act now you come through Lohem. And then in the transition period, you support all the associations to fulfill trade union processes and be properly registered and also. That's my argument.
Thank you, sir, for those comments as well. We'll take note of the suggestion made. Because issue actually no really small in the sense that unions consulted on this one 2 times ago to this one. So we have existing members who are members of association and members of trade unions. So it's an issue not within the public service, but it's based on broader consultation with the stakeholders. And the reason why those issues come inside there, because as you know, unions and associations are quite powerful in nature in terms of what like him. So time you deal with an issue here, you should also sensitive to issues surrounding the issue as well. Yeah? Because some of these associations are a long time now. It's been there for ages. So you cannot just come and say, okay, if we're out, this one for organizing for now. If we're out, so based on consultation with the unions, these are the issues we will talk about. So why I'm stopped now, let's build this time. Thank you, sir.
There is no need for anyone for out. There is no need for any association to lose any benefits or same. That's not what we're saying. You can recognize exactly everybody who's there now, all the associations. But what we're saying is for better governance of the industrial relationship between government and employees, we want one gate, one door. It's an act, Trade Union Act, was designed specifically for industrial relations. How Hemgogoem happened that government recognized him associations, we don't quite know now. It's history, and we've lived with it, and we've accepted it. But we're saying going forward, it's better that one way for deal law. And they may gain more rights because they're coming through the Trade Unions Act. But it just seems to me it's an abuse of the Charitable Trusts Act to register organizations that are actually industrial relations organizations under the Charitable Trust Act when you have a legislation there that actually specifically deals with it. So me not think about the unions necessarily opposed to him, because by him no deregister anybody. Just recognizing that this one now about our legal framework for recognizing you.
Thank you.
Thank you, sir. We take note of that. I think the issue of governance here, one big issue, Lord, issue of the associations here. It's an issue of governance, meaning the governance side of it, because I think if they've been registered under the Trade Union Act here, I think there's certain conditions you meet them in terms of governance too. I think that's the big issue here. So we will look into that and we'll talk with them in terms of this one as well, helping them to be. But I think members think, but it was several members of those associations. Because I'm not key. Once what say or image change him that association with Trade Union, I'm not key. And what structure and governance now, I'm just stable there. Because I think a lot of issues are raised in terms of governance. Not only governance about the structure, but funding and kind of some. So it has also been raised to us. So thank you for those suggestions. So we'll talk with them in terms of this one as well. Thank you.
Thank you, PS. Let's move on to clause 104.
So depending how you deal with that matter of association, by I'm affected more get everyone now. 105 to you.
Clause 106.
Yeah, 106 here, no apply to negotiations of terms and conditions contract of employment. So this one, forget PS and DS and OSEM. Okay, so get there, you cannot be a member of a trade union.
Come again, say?
Law 106 here.
Okay.
Division 2 does not apply to the negotiation of the terms and conditions of a contract of employment.
Yeah, thank you, sir, for those questions. Those under contract here, the terms and conditions, based on contract you sign him. Once you sign him, you agreed to those terms and conditions within a specific time period, 3 years, 4 years, kind of thing. So,
So this time here, where senior managers of public service work on contract now, kakam dan Kasimot FC, or no member of CPU na
no, or still member of CPU, those positions you mentioned, senior public servants. But there also some people who are on contract are still members of the union as well. By virtue, like we cannot stop a person and right blame for if he wants to member of union and to join him in union. So we don't stop anybody individual right blame for joining him in union and prefer for joining him. So,
but a person can choose not to join. So if you put him on contract that, you're contracted and therefore you're making a choice, then you sign him contracted that by you not join him CPU or by you not join him in a union, then they choose to give up that right. They have a fundamental right to it. But once they sign a contract, where deliberate, clear clause law there, say once you sign a contract, you're no longer, you renounce your membership of a union. Otherwise, this whole collective bargaining provision, how not by have no apply law terms and conditions. You're saying if CPU hemi say negotiate for 5% COLA, that one by no apply law contract personnel and apply no law line positions.
so in terms of one, I'm affecting everyone.
So there you go. Collective bargaining still affect them. So if you get member law CPU, they are for all intents and purposes part law collective bargaining, So therefore defeat him now, clause 106 here. So you can't have the best of both worlds. You either sign a contract and thereby make a deliberate choice by signing that me renouncing membership below any association or trade union. It's a choice.
So thank you for those comments. I think we will take note of them. I think by we address him two ways of contracts, make him time you sign him contract here, specify those things you mentioned him, because you give him up now rightly to become a member of union, because the contract you take him performance based. It's a good contract with him now. Normal public service take him. So, me, those contracts should make him seeking for new things, because you are well taken care of in that contract. More than any other normal public servant. So I think we should specify normal contracts or the silence. Since once the bill come into effect, those issues we make them. Then once new contract come, we put in no clauses for contract.
I'm also helpful. This whole issue, memorable or not, New Georgia raised him sometime last week on time for negotiating terms and conditions. Yeah, CPU come negotiate with the members of CPU no more 2 years. But once you say now, you sign him contract there, specific clause inside contract there, say you renounce him right blue for member law any union. And now that contract person is representing the government in those negotiations. There's an arm's length. So tied him up that area as well. There's no vested self-interest, conflict of interest in those negotiations.
So thank you for those comments. We'll take note of that.
Good, thank you, PS. Claims 107, association law, then by Lulukulo. That one by me also affect him. 107. Any further comments on 107? Clause 108.
What is good faith? In this whole context here.
Thank you, PS. Man, Jesus, lo heart blame.
Thank you, say, like, to me, the good faith there, like, if you do been in a negotiation, lo, with any issue, I must, you know, got many strings attached more, time work conditions, lo, the matter of negotiation, yeah. So I think the only thing no mean for dream law no is that him provide definition what na good faith could be what na definition of good faith, but to me, you making a negotiation, you know, got him strings attached them. What you give him here, him based law, right, and affordable money in which governments afford him. Not those things if issue with him, pay increase or other terms and conditions of Public saying. So him must be based on the decisions made. Firstly, it must be based on affordability, it must be based on legality of the things provided to you. So I think here, you raise an issue where what is good faith? So anybody can have what definition of good faith in this matter, but so I think we could provide a clause in terms of what good faith minimum when you acting on behalf of somebody exercising that power or you must not be ashamed to you. You must exercising that thing with good intentions based on clear guidelines and legal advice as well in providing that you at the table negotiating on behalf of the state or any union as well. Thank you. So I think definition blame na even for put him inside as well too. What na is good faith. O itanong man good faith, Jesus will heart to blame o kan mo. So we take note of that. We'll what part of the policy instruction for the legal drafter.
Thank you, PS. Take care of that good faith. Let's move on to 109, clause 109. (110). Clause 111, 111.
Subclause 3. So a period for which a collective agreement has effect. Not less than 5 years, not more than 10 years. Why not?
Thank you, sir, for the comments. Well, okay, usually time signing agreement him will put him between 5 years, him not less than 5 years. At least him got 5 years before he renew or he look at some of the issues within the agreement.
No, practice na.
Yeah, no good him sign this time no more. Then next year when I come back more, then he will talk about same issue. He talk about. And then I'm not more than 10 years. I'm shouldn't put him too long. So once custom 10 years, he may review several clauses or several part of agreement. I have no reason why I'm stopping.
So Samval Kasim 10 years?
Come again?
Samval logat a collective agreement say Kasim 10 years?
No, after 5 years, no, we will start for close obligation. More than 10 years, I'm no more. Most like
the longest one, how many years?
5 years.
5 no more.
Yeah.
Possibly put more than 10 years more for what more? You say no, must be not less than 5 years. Finish there now. Or you doubt your ability to review these agreements?
Maybe sometimes with agreements, maybe I'm constitute a little bit sum of money too in terms of resources for government. So sometimes I'm come with him a lot of resource too, what the agreements because terms and conditions here, most things due to miscellaneous. So sometimes we give government building space too in terms of how. So once 5 years, I'm okay me renew. That more than 10 years too. Like you look at the wage structure problem this time, public servant here, me give him call every year, no, in terms of others here, but other terms and conditions for the scheme of service here, him got him a good benefits to him. So what are more good than the others? So maybe those issues here, after 5 years, then renew. And maybe that review and not necessarily mean for either for increase him or decrease him. At least we visit the agreement again. Yeah.
Okay.
Thank you. Please close 112. Close 113.
Law 113 here. Trade disputes panel jurisdiction. Hemi including the associations or just trade unions? LD?
Sorry, the question?
The Trade Disputes Act. Process law, trade disputes panel, the referral.
Clause 113.
Way it's worded in the Trade Disputes Act,
Yeah.
does that include associations or only trade unions?
We will look it up. Yeah,
Okay.
the Trade Disputes Act. Does it include associations? That's the question, yes. We will look up.
Yes.
Sorry, I don't have the answer on my
yeah.
head. I will.
The other thing now with regards to strikes here, of course we must avoid strikes, you know, I wouldn't say at all costs, but the ideal is that no any strike ever, a civil service, so that services are being delivered. Yeah? Government is delivering its services to the economy and so forth. So we must avoid strike. So that's my first point. My first point is perhaps it should be put here as an aspirational objective to avoid strikes. You know, in your values, you said you aspire to wisdom. Well, in trade relations, you aspire to no strikes. So when there are no strikes, of course, it's not justiciable and go to court and say, oh, we breached this clause where we aspire to no strike because we're going on strike. It's just an aspirational goal, which then helps to moderate on both the employees, trade unions, when they're making their claims or demands on OSEM, to exercise moderation to make sure that we avoid a strike. And it also moderates the government's approach in responding to the strike notice, to say, okay, well, we don't want a strike, and therefore we see what is possible within our means, within the government's means. I'm thinking blue, yes.
Thank you. Yes, PS.
Thank you, Chair, and thank you, Leader, for that very important comments you made in terms of the strike. Yes, to us, you mean like I'm striking. I mean, strike happen because dispute happen in terms of certain conditions happen in terms of welfare block at command. So to us, we don't want strike from happen for all of us. But there may become a time where certain conditions are met, have a go and strike. But up until now, we are waiting at one. So based on several experience that happens so far, like Sinta issue, and recently Rosina, they issue a notice, but before that notice elapsed, we were able to discuss and look at the issues or talk about it. So it not happen. So under this clause and provide for strikes, which is me and I say tell them like we cannot avoid him strike. It will happen. It's a right of those members of trade union. If what aggravated by any issues that are like him happen, they could ask for. So this clause provides for that process.
Yes, please.
So this provision, stop not the strikes. But, so what the associations and unions go on strike. But should that be the case, then this provision 113 hem talem that refer or trade dispute panel for deal with them. I think that is also the current practice where the matters where have a tendency for what they can go strike, usually about refer or trade dispute panel. So that provision, yes, should there be a strike, hemorrhoid, but by refer or a trade dispute panel for deal under the Trade Disputes Act. Thank you.
You have an answer.
Thank you.
LD has an answer.
Okay, yes, LD.
Honourable Chairperson, in relation to the question, it appears to trade unions are also inside the Trade Disputes Act. And our definition for employee association under Clause 103 means a trade union under the Trade Unions Act. And under the Trade Disputes Act, it makes provisions also for trade unions.
So under the Trade Disputes Act, it doesn't provide for association. It just says Trade Unions Act.
It talks about employers association, unions, or associations.
Under the Trade
Disputes Act.
So it includes associations.
Yes.
Okay.
Okay.
Okay, law 114, Chairman. 1143A.
Yes, please.
I'm just wondering, should there be a time limit placed on that? Because you may, here refer to Public Service PS9, you may have even one or two officer no more misconduct here, I'm all right, but if it's like quite a large number, this would be quite an exercise.
So thank you for the comments as well. Thank you, Chair. So you're looking at, for timeline, this for the process here.
So the PS has to fulfill this reporting requirement here.
So this one here, the issue may be after the trade dispute and give this on blame, and then we find out that there are certain officers, then the PS for the ministry addressing this one some misconduct under Section 3. So if it was found to be a misconduct, I'm charged under relevant laws now. So if it depends which number of people or the name him come now.
So, but how are you going to know? PS blot nara or HR blot nara ministry siya report kam lo yun?
The reporting process and maybe through that process where those HR in the ministries or responsible officer in the ministry report those persons to the PS Public Service.
And you would want that pretty immediately. I mean, if a matter is referred to the trade disputes, next day, Ogut must come back work na. So that's why next day, a workable responsible officer is to go around and huna kam, huna no kam. Then forward them record kam lo yun na. So you know, leave him the drag out more.
So like, what the ministry should guide them now, attendance management. Boleh register and start with them or what. So if the person no report that day, misal huna no kam wakana. So those things should be on the fingertips of those responsible for administering that system within the ministry. Because if we got them too, that's for policy and stuff in place this time. So some ministries, they are going online now in terms of like, e-governments, like for us in terms of public service, morning come, you come click him and assembly, you appear to enter now. And time you go out, you click more, then you go out.
So, online now?
Yeah, whether HR na me PS public service, PS plus the HR manager no, will get access.
For looking huna o.
Yeah.
Finish.
Una check in finish. So after every Friday, so Monday morning, the attendance for last week, game come na huna come. So if you look at the graph, that patient constantly come 9 o'clock, you 7 or 10 patient na. So what we do now is that happen that way we call that patient no, what na issue blue. If you become constant, what me tell them got me linking will pay na. Deduct him certain part of the portion hours you leave him na pay blue. So we
every ministry
no,
also?
no, not yet. We are moving this before pilot and before.
Me looking lo parliament lo. Here too what Narde become FC go here.
Oh yeah. So I think certain ministries not garam this time, others maybe parliament and garam too. So this is a tool for managers for managing now. Wakaman kakam address him na absenteeism. So you know too well who comes early and who really am no sa kam waka. I mean come late every time.
So overtime too, or go here too? No more? Time out overtime?
We overtime yeah have not come inside law weekends yeah what must click into the for me. I said so there instrument lo front for you. But me linking with him video na ba. Link that thing with the video make you say what time no man virtually when time come. Because you gotta use your thumb or use your card.
Oh yeah man. So if I'm come put thumb and finish.
You.
Then thumb yeah. But then them go out, them go walk boat and lo market. But that also no.
Camera na ba detective him.
Yeah.
Em na sa mana kami lobby store come not them come pembred lo morning no come
Yeah.
come first time put him something them go out them go for no.
Yeah.
4 o'clock na come back inside so that camera na for determining. There are other cases where happen that way too, where certain people would give card lot for someone no, for him come click first time no some people detected for addressing issue. Through the use of camera na.
Okay.
Because you look man every time 7 o'clock na mula finish so ay kasi ang busit tumas mo don't open it inside na. So you look party so I'm not for time for look through oh this is an issue we need to address. We address it so I'm okay no. So we want this thing must across game at least in term attendance and The other issue too, in terms of productivity too, President him Kamlo office early doesn't mean that I'm productive in the sense that I can work on output now and give him. So we're also looking at those issues as well while addressing the attendance issue. So I must work, and now based on PMP, we talk about it now. So look at that person for a year. How productive is he in terms of coming to work, and that person not come to work. Those are the issues too, in for looking. But coming to work, you must come because of the GO. 8 o'clock now, work start. So it doesn't mean that they give an excuse that, oh, me man for produce a lot of report, and me come out for work, I'm okay. No. GO, I'm telling you, must come at 8 o'clock. So I'm the same giving you, unless the new orders come where you shall work from home, I'm doing for look them. A person can still work from home in terms of the new public safety orders if anything happens. So a lot of issues, a lot of things we will think about this now. So once this thing trust out, then we could move to a better and responsive public service. Thank you.
Chairman, lo part 12 here. Semimi talemba new tatalem golo LD. But I'm good for story with him, Chairman, Law Reform Commission. He's done some analysis, quite a helpful analysis in terms basing it on the 2009 Miscellaneous Penalties Act. So have a look at that, and then we may make him same.
Yes, Honourable Chairperson, yes.
Thank you, Leader. So PS LD take note of that. That allows us to move to part 13. Can we?
Yes.
Part 13? Yes.
Nikis come now, no mate.
It's very in time now.
Close
No hurry too much. Nikis no hurry.
to 4. Thank you. We move on to clause 1 to 5. Clause 1 to 6. Let me move now, Leader. One to 7.
1 to 6 to be
1 to 6 to B. Yes, Leader.
Is that just a typo or the second line?
It is a typo. Thank you.
Thank you. PS take note of the typo.
2 2 2 6 2 1 2 6 2
1 to 7.
typo.
1 to 7 2 here is becoming quite a standard provision in. I have noticed it since about 2009 onwards that this has become a standard provision in a lot of legislation where I'm coming. I mean, it should go without saying, I suppose. Something done in good faith, but wrong, well, you can't really hold that person liable. Sometimes me, something you look him done in good faith, but really Satan no underneath. Boys, yeah man, money Jesus lo hat blame but away. To all horn will be an hit blame.
Thank you, sir. I think that one by the legal draft team number, so what actually really minimum for part of them. So say them, this one I think every bill hem come of parliament, they think that him it's a standard clause and stuff inside.
Thank you. Is it your favorite LD?
Honourable Chairperson, I'm not sure if I'm to comment. Yes, it is not here only, but in other jurisdictions.
Yeah.
Yes, it's simply really to say that, yes, as Honourable Leader has said, but that to allow A, B, C, D, E to carry out in good faith as much as possible, as best as possible, the highest, and not, if you've done it the best way, you cannot be liable for this. But 3 still has that check, monitoring, liability is there if you're liable. So while it does give that protection, at the same time, if you have abused it, then you are liable. Thank you.
Thank you, LT, for that clarity. We move on. Can we do 128?
One, 282.
Yes, Leader.
Yeah, LD could explain that.
Thank you. Yes, LD. 1282.
128, Honourable Chairperson, 1282 allows a person to take action in 1281 despite any law about confidentiality. Again, still within, it's still to encourage that work done in good faith without criminal civil liability, but it's still subject to law, written law. If the other law says it is a breach to do so, then that also has to be taken into account. It does not. It allows a person to continue despite that there is a provision there. Within that provision, action, you may still continue to act within the confines of your act and that law.
Really? I thought it was the other way around here. So yes, in spite of, because it says despite
any written law
about confidentiality, that includes this law. The provisions here about confidentiality we talked about before, despite those provisions and any other provision in any other law, Whistleblowers Act and Leadership Code Commission, Auditor General, he doesn't have an act, any other law that protects confidentiality, law here say any person may take an action specified in subsection 1 despite those laws.
Yeah, within
Bring the other way. Say, don't worry about those laws. You take your action as you think they're lawful.
Honourable Chairperson, when we say don't worry about those laws, it does not mean that you are not liable to, if that law makes your action illegal under that law, still a process in this
Really?
and that.
But subclause 1 says no person incurs civil or criminal liability.
Only if in A and B.
Correct.
Yeah.
So then in 2,
Under this act.
yeah, in 2, if your action is being taken under 1, which includes A and B, well, never mind the confidentiality.
In the other
In
law.
any other, well, this law or any other law,
But you're taking action under this act.
you're taking action under this act.
And that action, never mind that law. But
Yeah.
it's not as specific as that, because that law still must be taken into account.
Right. So only if you inadvertently, you may breach that confidentiality? Is that protected here?
if it will go to the merits of the case. Yeah, if the inadvertence, there's no intention to do harm, then all these facts can come up into. But the point in 1 to 8 is to encourage the work done in good faith to be read in that context. So if you work and you incur, no person incurs civil or criminal liability only if reporting actual or suspected employee misconduct in accordance with this Act, or complying or cooperating with the process under this Act. And there's a confidentiality in another Act. Continue working here. That should not stop you from carrying out what you need to do here. But at the end of the day, the merits will come out to see that it does not breach any law.
Okay.
Thank you, LD, for that explanation. Let's move on to 129, clause 129. Favorite blue now, leader?
Is 129 constitutional? What does the Constitution say about public officers, candidates for elections?
I think, Honourable Chairperson, if we read it together with subclause 2 and 3, they are to be read together.
Yeah. But are they constitutional? What does the Constitution actually say?
About
Public officers.
candidacy.
Yeah.
If we
Can they? I thought there was a provision under Parliament, election to Parliament.
one must resign.
What section talks about Parliament and election to Parliament?
Part electoral commission.
Huh?
Just look it up, Honourable Chairperson. Elections. Constitution. Constitution. To elections, yeah. I think it's A4. Qualification. Part 1. 6. Qualification for membership. 48. 48. My goodness. I'm reading. Right, yeah. Right. General. 74 is it?
49B itu
The Constitution.
49B
49. How qualifications for membership? 49B.
So 49(1)B seems to be the only one that talks about public office. So a person holds or is acting in any public office. But a person who's on unpaid leave is holding and acting in public office?
unpaid leave, he's still a public officer. Salary blame no ma'am for system, because him what at call him approve authorized leave na him ask him,
Yeah, but that one public officer, which defined law 144. him acting in office, public office. So if you go 144 public office.
Because him
I think
needs to be holding a public office.
That's electorate.
Public office means subject to the provisions of the next following section, an office of emolument in the public service. So if you see him payable him, I'm not take emolument. So no public office.
Yeah, legally. And, yeah.
And public officer, although 49(1)(b not talk about, but public officer means a person holding or acting in any public office. The public office now, determinant of public office now, emolument in the public service. But if you see him payable him, unpaid leave, I'm outside of this now.
Belong to public office. Yeah.
LD, what do you say then?
Sorry, may I take the question, please, so we can look it up and come back if we need some more time?
Is a public officer on unpaid leave qualified, eligible, qualified to stand as a candidate? So here it talks about you must resign.
Qualified.
Law subclause 2 here, 129 subclause 2 is that ultra virus the Constitution.
Repeat the question, please. Is a public officer on unpaid leave qualified to be a candidate? This is the question
Parliament, yeah,
to Parliament.
yeah. And therefore subclause 2, 1292 is it ultra virus the Constitution.
92. Is it? Thank you. We will take the question.
Thank you.
So he ceased to be, unless we go up and do away with him unpaid leave.
So I will take the question because most of this also we
Yeah.
need time to look at it. Thank you.
But look, we come back law Friday or something, Thursday. Well, how long do you need? To give further instructions to the LD second head now. No, we won't talk about time. You talk about this.
Maybe next week. We will plan for this week finish. Once we finish the hearing today, we will meet on Wednesday. We'll sit down, look at those issues, then look at which instruction, police instruction by LD. So we will do those by Friday. So Wednesday we will meet. What game come notes block at?
Tomorrow no, we meet Wednesday for what more? Today we because I go lunch now. Then you finish now. Afternoon you will meet now.
I think they have the LD is busy with another agent instruction for them on legal drafting. So
Okay.
we give him time today afternoon, tomorrow from Wednesday night, come back, then we'll meet more.
Okay.
So our team will go back to them, we start to look at the issue we raised, and then put together notes. Then we'll meet on Wednesday, and we'll give instruction for doing that. So by Friday, those things will come back. So by any time next week, we could come back to you with a list of things we talk about.
Because we will be working on our report this weekend.
Okay.
So once you Friday will bounce, you say Friday will bounce back up.
Yeah.
Then that will inform our recommendations.
Okay.
13 no more Parliament meeting, which is following Monday no more.
Okay.
And it seems this will be the only business for Parliament, so you must report.
Okay, we'll certainly do that. We will try this week, we'll finish him every report by Friday and should come back level.
Very good.
Thank you.
Thank you, PS.
We will do our best with this bit of research to do
Yes,
legal research.
True.
Thank you very much. As leader continue to remind us, Jesus Lord pray for us by him trust him. But, as leaders alluded to, yes, this could be the only business for us, this coming meeting. So it's good that we allow ourselves time to really address our issues now before he may catch up law number 13. Yeah. So we'll meet back Friday. Okay.
Yes, Friday.
So yeah. And I think the process we have gone through has been helpful to us. We've come across him that one in the recent bills. And if you follow that approach, discuss, look at the issues here, and then me look at more look at the closest blame by him help and build blame for strong good. I didn't wait him that one, him told by blow here. Yes, LD, you seem to be having some more questions.
Just confirming, Honourable Chairperson, we will come back to finish this up to clause 134. Are we completed now?
We completed that.
Okay.
Yes.
All right. Thank you. We will try our best for the. With the
Yes.
legal research.
Yeah. So we have now concluded the clauses. We are happy with the remainders up to clauses 134, and waiting that one you are now to go and look at the issues that we have raised during the clause by clause session. And then we meet again Friday. Came him to look at the issues how we will address him come. I think with him that one committee members blow me feel happy to myself PS with him your team members and also legal draft questions for him sit down come and him finish him what close here. Let's look forward to Friday and by him to close law here. We'll close with a word of prayer. Yes. Yes, you will come so attend by me to call you pray for you.
Okay, close your eyes. Father God, Heaven, Lord, as we dismiss from this place, Lord, we pray, God, we thank you, God, for the knowledge and the wisdom, Lord. Lord, that you guide me, Father, to come here finish him now, this Father inquiry, Lord. Lord, stay continue, Lord. Me pray, God, protection hands play over me, Father, Lord, as me for go back, Lord, respective of this play, me, Father, Lord. We pray, Lord, these things in Jesus' name. Amen.
Amen. Amen. Thank you.
Thank you.